Thank you, Speaker. I rise to speak on behalf of the Greens on the Mandatory Disease Testing Bill 2020. The description of the Act sets out that it is an Act to provide for mandatory blood testing of a person in circumstances where the person's bodily fluid comes into contact with a health, emergency or public sector worker as a result of a person's deliberate action, and the worker may be at risk of contracting a blood-borne disease. However, the bill, as it currently stands and is drafted, does not in fact deliver on this aim. The bill includes problematic assumptions, outright inaccuracies, not to mention gaping holes, unworkable timeframes, failures to ensure adherence and actions based on health advice, as well as questions about the basic concepts that form the basis of our justice system. But before I go into the serious flaws in this bill and outline the amendments that we will be putting in this place to try and address these concerns, let me be clear. This bill is unnecessary. It is based on flawed assumptions, outdated and frankly offensive views, and it is for that reason that the Greens strongly oppose this bill. If the New South Wales government is going to shred anything, then I would say that they should shred this bill. This is not about COVID. And I recognise that many people in our community are feeling particularly anxious, stressed, fearful and vulnerable currently about the highly infectious nature of the current pandemic we face. But this bill is about mandatory testing for blood-borne diseases and has been on the table and a threat to our community for many, many years, well before this current situation. It is crucial that no member in this place tries to spin this as being about some response to a current health pandemic. That is a Trump-esque form of truth and should not be entertained in this place. In conversation with Nicholas Parkhill, the CEO of ACON, the other day, he reminded me that mandatory testing has always been a challenging policy issue that ACON and other policymakers have had to deal with. He shared with me a section of Fighting for Our Lives, the book that about ACON and the history of New South Wales HIV response, which details in some historical policy struggles and context, and I'd like to put it on the record here. It reads, "The forced testing could tell people who to avoid, insurers who to discriminate against, employers who to dismiss, and authorities who to detain. This was not an idle threat, with surveys showing that up to half of the population supported quarantine of people with AIDS. The task fell to ACON over and over again to explain why mandatory testing was a bad idea. Mandatory testing would have been an obvious vote winner, so it is remarkable that it was never seriously considered by major parties. Blewett categorically ruled it out, declaring in 1989 that public health and individual rights march hand in hand on the AIDS issue, while the Conservatives maintained bipartisanship on the issue. It is one of the greatest achievements of Australia's federal politicians that they were able to resist such a popular measure, governing through compassionate pragmatism rather than ill-informed public consensus." Many decades later, in 2017, in response to this issue again being raised, this time while I was sitting on the Law and Justice Committee, and I note that the chair of that committee at the time is in the chamber today, we continued to hold the line against this when there was another push to try and get a strong recommendation to introduce mandatory testing, and instead the recommendation directed that the Health Minister consider whether or not this was necessary, and no action, it should be noted, was taken by the Health Minister in relation to that recommendation. It was a huge concern to our community then, and it is of huge concern to the community now. This is not a new issue. It doesn't need consultation, it doesn't need an inquiry, it needs to be shelved. In a letter signed by Hepatitis New South Wales, the AIDS Council of New South Wales, Sex Worker Outreach Project, New South Wales Users and AIDS Association, the Australasian Society for HIV, Viral Hepatitis and Sexual Health Medicine and Positive Life New South Wales back in 2017 to that inquiry, these organisations with decades of experience working in the area of bloodborne viruses, including supporting the community, the medical professions and research, articulated their concerns and put it simply. The idea of imposing mandatory testing for bloodborne viruses in this situation does not equate with the current medical and scientific evidence concerning the transmission of bloodborne viruses, including HIV, hepatitis C, and presents huge risks to the community. I want to acknowledge that also sharing the concerns raised at that time and in current debate include Bobby Goldsmith, the National Association of People with HIV Australia, and the Australian Federation of AIDS Organisations that is located on King Street in Newtown. The premise is totally flawed. The proposed mandatory testing regime does nothing to address any stress for frontline workers who have been put at risk of bloodborne virus infection, as it is based on a complete misunderstanding of how bloodborne virus transmission occurs. Such laws will, however, mark a fundamental shift in the rights of individuals' right to privacy, to integrity of their own selves, and a fundamental change to the established, successful and globally respected Australian policy, which has been founded on the principle of voluntary consent for HIV and other bloodborne virus testing. Given this clear evidence and based position from experts, can I just say that I was absolutely flabbergasted to see the New South Wales Labor leader Jodie Mackay announce late last year the intention of Labor to introduce a bill like this one and re-kickstart this debate. This came out of nowhere. It was not supported by science, by the health sector, and it was immediately criticised for what was being dangerous, for being dangerous. This from an opposition was just mind-blowing, disappointing to the extreme. And hopefully, the New South Wales Labor Party and the people inside it who know that this bill is flawed will be able to shift the position of the opposition before we get to the point of having to vote in this place. In fact, during the 2019 state election, I sat at a forum at ACON organised where the Labor Party was directly asked what its position was on this issue, and the response that they had at the time was strong agreement with ACON's position and stated that they have no plans to change the current law. A mere 7 months later, once the election was behind them, New South Wales Labor turned around and did the exact thing that they had assured the community that they would not do, ignoring the evidence, ignoring the concerns, and playing politics once again with people's lives. Make no mistake, we are in this place today talking about this bill because the New South Wales Labor leader Jodie Mackay opened this door, and that is disgraceful. This bill is another in a long line of undercooked bills that have come to this House in recent times that falsely assume the only way to resolve the law and order issues in this society is to increase police powers. I'm going to say it again. It is nonsense that this is the way that we do this. As we have seen during COVID-19 and many situations before it, increasing police powers does not achieve behavioural change. It does not make us safer. It does not relieve and resolve the underlying concerns. What it does do is increase the opportunity for frequency of members of the New South Wales Police Force to abuse their positions to the detriment of the public, and in doing so, causes tension between community members who want to rely on members of the New South Wales Police Force to keep them safe from people that will cause them harm. But this is undermined by the law and order approach that is currently being delivered and has been delivered. Successive Labor and Liberal governments in this place have operated under the fallacy for ever-increasing police powers, pandering to undue influence of the New South Wales Police Association, and you only need to look as far ahead as the business paper later today, where we'll see a debate come on to try to seem to introduce the ability for a police officer to conduct a search warrant on an individual without a warrant. With every bill like this one, our rights as individuals, our civil liberties are being eroded. However, despite all of this, when it comes to bloodborne viruses, there is another history. One of collaboration, one of not playing up to community fear, one of listening to the health experts and focusing on education and awareness, raising instead the targeting and finger-pointing. It is our hope that the government will recognise with this bill that they have taken the wrong path that our history has set for us, and that the Premier and the Health Minister and the Attorney-General and others will recognise that this is not the way to proceed. This bill is also an insult to frontline police and emergency service workers and other workers covered by the bill, as they are also placed at risk by the dangerous assumptions and false narratives that this bill and the supporters that seek to advance us are putting in place. If I may, Speaker, just to seek a short experiment of time just to talk through the amendments that we'll move so members are aware of them.
The member for Newtown seeks an extension of time. Is an extension of time granted?
Yes.
Thank you.
The member for Newtown.
We need to recognise that we need to protect first responders and others working in the public service from risks so that they are safe in their workplaces. But this bill is not the answer to doing this. As I mentioned at the outset, I will be moving a significant number of amendments to this bill, as I understand the member for Sydney will, in order to address some of the concerns. It does not change our position that this bill is needed, but if it is to proceed, it is absolutely crucial that there are some basic fixes to this bill to make sure that there is at least some fairness and a removal of some of the flaws that are currently standing in it. These amendments will ensure third parties cannot be detained for the purposes of seeking or enforcing mandatory testing. Extend the period that a third party can seek to review by the current Chief Health Officer from 1 business day to 7 business days. For any application for mandatory testing to include a statement by a relevant medical practitioner about the need for testing after having considered the risk, and ensure the senior officer refuses the application for a mandatory testing order if the relevant medical practitioner does advise that testing is not required. Broadening the people and organisations who are consulted in the development of the guidelines for how this mandatory testing will be conducted. Only allowing a senior officer to delegate their responsibilities to another senior officer, and ensuring that they do not delegate to a senior officer that is involved or connected with the incident, and preventing the use of force by a law enforcement officer against a third party to be able to take blood. All of these amendments seek to improve the bill that currently stands before us. They do not, even though we have very, very strong opposition to the idea of mandatory testing. None of what is put into this bill as amendments being brought forward today by the Greens seek to remove the power to engage with mandatory testing, something that we actually oppose. However, the amendments that we are putting forward do provide additional protections. They provide additional protections to the third party who is subject to the testing, and they provide additional protection to the person who is making the application for the mandatory testing order, because it is crucial that we do not fuel falsehoods about the risks to people working in these frontline services and these frontline spaces, and we also ensure that there is time to consider for a review and an informed discussion about how this is rolled out if it was to occur. The Greens will always side with the need to protect vulnerable communities from state-sanctioned intimidation, harassment and vilification. We will always stand up against excessive powers being given to police and other enforcement officers. And we will always work to ensure that vulnerable communities and people at risk from this kind of flawed legislation have a voice in this place by ensuring that they are able to live free from fear and with dignity. I would urge all members of this place, particularly members that I know understand that this bill is motivated by a sense of whipping up fear against certain types of people in the community and providing a level of placation to people that will not actually assist in their safety, to really look at whether they feel comfortable about supporting this bill. I recognise that it is likely that this bill will go to an inquiry in the other place, but there is a strong message that particularly the New South Wales Labor opposition can send in starting that inquiry process if it was to pass with government support in this place. If the New South Wales Labor Party today made it clear that they do not support the bill in its current form, it would not, like Jodie Mackay did last year, open the door for this really problematic reform to go through, but instead would make the government think twice about whether this is the actions that they want to take. It is absolutely crucial that we recognise that for decades and decades, people working in the space around bloodborne viruses and diseases have worked to try and make sure that people suffering from those viruses do not get intimidated, they do not get isolated, and they do not get excluded from our community. We need to make sure that we do not set back decades of work in that space by passing a bill here today that will seek to further vilify and once again isolate people that are needing our help. Vulnerable people in our community that do not need powerful people like us in this place from instituting laws and enshrining laws that will actually allow them to be further intimidated, further violated, and not have their rights respected. We do not need this bill.
We absolutely do need to do things to make sure that frontline emergency service workers are protected. We absolutely do need to make sure that people are trained in the risks and to keep them safe. And we absolutely do need to make sure that there are not violent escalations on any people working in the public service in the interests of our state. But this bill does not do any of that. It creates further fear in the community. It demonstrates and advances falsehoods. And it's for that reason that the Greens strongly oppose this bill before us now.
Mr. Speaker.